Morning, everybody. Welcome to our session. It's lovely to have you all here today. I think we're all being taken slightly by surprise by the speed of this latest raft of legislation and compliance obligations for trustees. Some of us have been watching it coming down the track towards us, but here it is, it's actually in play. And there's been very little time for us in practice and yourselves in commerce to process and to digest all the implications. The object of today's speed dating session is to make us all broadly familiar with the concepts which have been introduced. There's terminology that sounds vaguely familiar to some of us, but which has been used in a slightly different way. And our presenters today will try and illuminate some of the terrain and answer some of your questions, but it might well be that they leave you with more questions unanswered as you try and apply these rules to the unique circumstances. As we all know, trusts are used in very many and varied ways in this country. And one can't even try in a presentation of this duration to try and cover all of the bases. So please take the general principles that we're going to share with you today and feel free to engage with us. There won't be a formal Q&A session due to time constraints, but feel free to put your questions in the chat. If we can, we'll deal with them on the fly, but if not, we will certainly come back to you afterwards and engage with you directly. The speaker's contact details will also be shared with you, and we really, we'd be very open to evaluate dialogue after this as we will start coming to terms with the practical implications. The session will be recorded, so if there's any dropouts due to load shedding or other issues, you will be able to review it in slow motion if you wish. Okay, that's enough from me. We are going to kick off with Dion and Anika. The speakers will introduce themselves as they go so that you can become familiar with each of them in turn as we get there. Dion, Anika, can I hand over to you to take us away? Thanks.
Good morning, everybody. Thank you very much for taking the time to join this webinar today. Please just allow me to start with the presentation. So just by way of introduction, I am Anika Potgieter, and I work at the Private Clients Department at ENS Africa. So as some of you may be aware, towards the end of last year, a host of obligations and measures were legislated in an effort to strengthen South Africa's anti-money laundering and terrorist financing controls ahead of a potential grey listing. Supporting these new measures included a review of the role of trustees in the administration of trusts. As a consequence, somewhat burdensome and far-reaching obligations were imposed in terms of the Trust Property Control Act. In terms of the negative aspects, the amendments to the Trust Property Control Act were quite controversial at the time. It created noise in the industry as it was implemented without really taking into account public comment. So essentially, practitioners started panicking as they were expected to comply with the amendments by 1 April this year without adequately understanding what these regulations entailed. So it was only until 31 March that the final regulations were actually published. So for the most part, a lot of the practitioners were in the dark. Subsequent to the grey listing, there's also a cost factor to consider, in so much as it's now become significantly more expensive to administer trusts. And we will deal with, due to the enhanced due diligence, which we will deal with a little bit later. Nevertheless, I think most of the dust has settled, and we have a little bit more clarity now on what these regulations entail, which I will be discussing today. So as mentioned in the introduction, a trust certainly still has a place in terms of tax planning and other reasons for it. And that is essentially why this is relevant. Also to consider some of the positive aspects, the amendment certainly creates a new opportunity, I think, for trustees, independent trustees, and firms providing trust advisory and administration services. We say that because the likelihood of obtaining professional advice from specialists in the field is likely to be increased since the enactment of the amendments. This also provides an opportunity to trust to regularize their books. Essentially, we know now that the days of messy trust administration are over. There is an enhanced compliance aspect to it to mitigate money laundering risks. There's also now an opportunity for independent trustees to reevaluate the fees that they are charging in context with the risk that is being undertaken. Another positive aspect is that active involvement of trustees, due to the risk factors now imposed, inactive trustees will to a large extent be extinguished. And then lastly, this is probably a step in the right direction towards combating money laundering. In terms of context, just to revisit the grey listing, the Financial Action Task Force, FATF, the grey list refers to the FATF's practice of publicly identifying countries with anti-money laundering deficiencies. So South Africa was placed on a one-year observation period in October 2021 by FATF, and despite its efforts to rectify the problematic areas, legislating certain amendments, South Africa was still grey listed in February 2023, so thereby being classified as a jurisdiction with increased monitoring under the FATF. Why this is important is that FATF identified insufficient transparency in relation to beneficial ownership, and by implication increased risk in terms of trust for money laundering and terrorist financing. So what's important here is just to identify some of the key actions required by FATF, the relevant one being to make available in a timely manner accurate information about the ultimate beneficial owners of entities, such as companies, trusts, and non-profit organizations. Now, in terms of this grey listing, a question that we've received a lot was whether South Africa would be given any type of leeway. A lot of overseas firms seem to think that perhaps there might be a grace period or leeway in terms of the grey listing. So just to clarify that position, we haven't received any type of grace period or leeway, indication of leeway in our legislation, nor the directives from the Master's Office. So I think it would certainly be unwise to think that we would be given any type of leeway. I think essentially what is being demonstrated in the message that is clear that it's being sent is that our authorities will be supervising the information that is being supplied to them. In terms of the concept of beneficial ownership, just to revisit where it all started, FATF defines a beneficial owner as a natural person who owns and takes advantage of capital assets of the legal person and those who really exert effective control over it. So the definition essentially covers anybody who directly or indirectly ultimately owns the relevant trust property or exercises effective control over the administration of the trust. Now, to deal with the amendments to the Trust Property Control Act, as we can all see, the commencement date, again, just to clarify, 1 April 2023. In terms of the amendments, a new section has been introduced under Section 1 to define accountable institution and beneficial owner. The definition of beneficial owner we will be dealing with a little bit later in the slides. Then also Section 6, subsection 1A has been introduced. This essentially provides that there's a grounds of list for disqualification of trustees. So just in context, a somewhat surprising omission from the Trust Property Control Act before its amendments was a list on which trustees could be disqualified from being authorized as a trustee. Although Section 20 of the Trust Property Control Act did deal with the grounds on which a trustee can be removed. So these two aspects are essentially distinguishable. Section 6 has now been amended to include a disqualification list. So most of the grounds in that list is rather obvious. It sort of includes unrehabilitated insolvency, prohibition from acting as a director of a company, being declared a delinquent director, removal from office as trustee on grounds of dishonesty, minority, and similar disability. So these grounds, they appear to align with the Companies Act. One of the more unusual grounds is being the subject of the United Nations Security Council resolution requiring member states to take action against you. So this requirement we see is more aligned with FICA. So the interplay between Section 6 and 20 comes across to the extent that the master is now allowed in terms of section 20 to remove a trustee on any of the grounds listed in section 6. So the previous position regarding the removal of a trustee was also dealt with in terms of section 20, and it stipulated that the court may, on the application of the master or any interested person, remove a trustee from office if it is in the beneficiary's interests. Moving on, so section 8 has also been amended to stipulate that foreign trustees are eligible to act only with written authorization by the master. So previously the section dealt only with authorization. Now the word written has been inserted, and what is implied is that a letter of authority in respect of any foreign trustee is now required. So in terms of section 10 of the Trust Property Control Act provides that a trustee must deposit trust money in a trust account at a banking institution. This section has now been expanded on by addition of subsection 2, which provides that a trustee must also disclose their position as a trustee to any accountable institution with which that trustee engages in that capacity. And they must also make it known to that accountable institution that the transaction relates to trust property. Section 11A, new. So this is where the obligations come in. In terms of the new section, trustees must establish and record beneficial ownership of the trust, keep a record of the prescribed information relating to beneficial owners, which we'll be dealing with, lodge a register of the prescribed information with the master's office, and ensure that the prescribed information is kept up to date. The master must also keep a register in the prescribed form containing the prescribed information, and the trustee and the master must make the information contained in the register available to prescribed persons. The prescribed persons are amongst SARS, the National Prosecuting Authority, intelligence services, and the like. So in terms of the further amendments, and specifically the prescribed information in relation to each beneficial owner identified by the trustees, that includes their full names, their dates of birth, nationality, official ID or passport, citizenship, residential address, domicilium address, means of contact, tax number, class or category of beneficial ownership under which the person falls, the date on which the person became a beneficial owner, as well as the date that the person ceased to be a beneficial owner, and in respect of minors, their guardian's information. So this is essentially the list of information that is required from trustees. Section 19 has also been amended. So in terms of section 19, a trustee failed to comply with any obligation referred to in section 10, subsection 2, that's relating to the disclosure of status as a trustee when dealing with accountable institutions, or section 11, 1 subsection E, that relates to the reporting of details to accountable institutions being used as agents, or section 11A subsection 1, dealing with the recording of information relating to beneficial owners of the trust, commits an offence, the maximum sentence of which is a fine of up to 10 million rands or imprisonment for 5 years, or even both. So on a high level, I think our view is just that the penalty for failure to comply with the trustee's obligations and duties that's now been amended is potentially very, very heavy. In terms of the Trust Property Control Act, the definition of beneficial owner is important. So what the Trust Property Control Act amendments have introduced is in respect of a beneficial owner, it means in respect of the trust instruments, the first category, a natural person who directly or indirectly ultimately owns the relevant trust property. The second ground, a natural person who exercises effective control of the administration of the trust arrangements pertaining to that trust. Third category, each founder being a natural person, or in the event of it being a legal person, then the natural person who directly or indirectly ultimately owns or exercises effective control of that legal person. Each and every trustee being a natural person, again, where the trustee is a legal person, then the natural person who directly or indirectly ultimately owns the relevant trust property or has control over that legal person. And then each and every beneficiary named in the trust deed. And in the event of it being a legal person, again, the natural person who owns or exercises effective control over that legal person. So essentially what we see here is there are 5 categories being subdivided into further categories, and it always comes back to the natural person. bearing in mind the type of information that must be submitted in respect of each beneficial owner. So essentially, the new host of obligations of trustees are then contained in section 10, subsection 2, section 11, subsection 1, and section 11A. Just to recap, a trustee must establish and record the beneficial ownership of the trust, keep a record of the prescribed information in relation to beneficial owners, lodge a register of the prescribed information with the master's office, and ensure that the prescribed information is kept up to date. So this last requirement in terms of keeping it up to date does not imply that trustees can retain the register with them as they continually update it. It simply means that information must be submitted and must be up to date at all times. So in terms of the concern about the new host of obligations of trustees, most of the concern that we found was expressed about the amendments relate to the issue of beneficial ownership of the trust. So particularly the definition of beneficial owner. Prior to the amendments, concern was expressed in relation to the definition that it threatened to undermine established principles of our law relating to ownership of the trust assets and vesting rights in beneficiaries of the trust. On a high level, observations are that the definition of beneficial owner merely serves to establish which persons in relation to the trust whose identity and details must be established and recorded by the trustees in accordance with section 11A. So the purpose of the provision is to avoid persons from sheltering behind some or other identity for money laundering purposes. Again, the objective of the amendments. So it is not to create new proprietary rights to persons labeled as beneficial owners of the trust, and specifically here in the context of discretionary trusts. So the new duty to establish and report the beneficial ownership of the trust might not be unduly burdensome in respect of most of the categories, right? So you have the founders, the trustees, and the named beneficiaries of the trust, and that is rather straightforward. So where these persons are not natural persons in terms of those three categories, the duty to establish the natural person who ultimately owns that legal person or exercises effective control over that legal person, that might well prove burdensome. The same comment applies to our first two categories. So the first one being a natural person who directly or indirectly ultimately owns a relevant trust property. So what we must note here is this refers to beneficial rather than legal ownership of the property, right? Since legal ownership is vested with the trustees. So since the founder, the trustees, and the named beneficiaries are already included in the amendments, this provision must presumably then refer to someone other than the founder, trustee, or named beneficiaries that might ultimately benefit from the trust property. So this again refers to somebody that might be sheltering behind someone else for money laundering purposes, or just in general, the first category, somebody who does indirectly or directly benefit. So how trustees can be expected to establish this is indeed the case, is quite burdensome, and it might be problematic, and that is probably best left with the professionals. So in terms of the category of named beneficiaries, again, this refers only to the named beneficiaries in the trustee. So where the classes needs to be identified, the persons in particular classes, that is open to interpretation, and we will also be dealing with that a little bit later. This is just an illustration of the masters registered. So you can see this register was compiled in terms of the regulations. The master's office has this register contains slightly less information. Again, what we must remember here is that the register does not take away from the trustees' regulatory obligations to keep the information detailed in the regulations with them. So in terms of the requirements, as you can see here, what it sets out is that you would need to fill in the following information to the master's register. It's the trust name, the file number, grounds on which a person is a beneficial owner of the trust. Again, here we have our categories of a founder being a natural person, founder being a legal person, trustee natural person, trustee legal person, beneficiary natural person, so that refers to in the trust deed, and then beneficiary legal person. And then here we've got our last two categories, other natural person who directly or indirectly ultimately owns a relevant trust property, and other natural person who exercises effective control. So this list is not a list of or, it's and, meaning that you would have to identify those beneficial owners. And in terms of each and every beneficial owner, give their names and surnames, ID number and type, nationality, residential address, domicilium, email, contact number, date on which the person became a beneficial owner, date on which the person ceased to be a beneficial owner, and obviously representative details in the case of minors. Now, what's important to note here, and it's quite critical, is in terms of the capturing of information, there are two mutually exclusive options for submitting the information to the master's office. Either one, the trustee submits the information themselves, or two, a capturer acting on behalf of the trustee may submit the information by means of a signed power of attorney. Now, this is important in terms of the context of liability. The power of attorney is also useful to the extent that if information is regularly updated, there's no need to include a new power of attorney time after time. So in terms of the capturer submitting information, they also then have to sign a declaration confirming that the trustees are keeping in their records certified ID copies of all beneficial owners of the trust, and in respect of minors, their guardian IDs. Why this is important? Authorization to attend to and deal with the matter and to verify the authenticity of the submitted information. So this clearly implies a verification obligation in respect of the person that is submitting the information. So also the last category, that the information submitted is true and correct. In the event that the information is not true and correct, the master has inserted a disclaimer on its behalf. The master of the High Court will not be held liable. So this clearly places 100% responsibility in terms of, in the context of liability on the trustees as well as the declarer. Just a few observations from our side. The effective date, again, 1 April 2023. This essentially means that trustees would have already had to submit the information. Is there any type of grace period? No, there is not. Does legislation require trustees to disclose information to the master or just inform the master that it's available? Again, our regulations expressly provide submit. Do the obligations apply to individual trustees or trustees on trust? The legislation specifically states a trustee. Again, we can interpret that. And only current beneficial owners or all historic ones. We do not have clarity on that aspect yet, but I think it's important to always keep in mind the objective of the amendments. Again, we must always distinguish between the regulatory obligations of trustees to have this information versus what must be submitted to the master. For argument's sake, if one trustee submits it, it does not absolve the other trustees from having that information when called upon to disclose it. So also another observation, the beneficial ownership, specifically the category 1 and 2, which are the more difficult ones, that refers to a factual inquiry, which is perhaps then best left with professional attorneys and advisors to determine. In terms of the IT3T tax return, just a few remarks. Where it comes from is that there was a gap in the range of 58 billion rand of distributions by trustees and declared by beneficiaries that was picked up by SARS. The submission date for this return is 18 September 2023. And then there might be certain capacity issues. So that is the feedback that we're getting from stakeholders. SARS system might not be ready for this tax return to be submitted, and it might be likely that it will be voluntary submission and not compulsory submission, depending on whether SARS system is in order. So just in terms of concluding remarks, in a nutshell, some of the most critical observations is that there might be practical implementation issues in respect of the amendments. Some of the amendments are open to interpretation. We also asked the question in terms of the fees that independent trustees are charging. There's also certain data privacy concerns. It seems that the prior position was that you would need to have an envisaged right to be able to access information. And now perhaps the position is that this information might just be disclosed openly, where any member of the public draws a file from the master's office, for instance. Again, hefty penalties, burdensome duties, and we will be dealing with those a little bit later. In terms of a poll question, I will just hand over to Dion.
Annika, thank you very much for that. I thought that was very useful, very valuable information. I mean, there's a lot of information digest. So for those of you who don't know me, my name is Dion Beechan, and I am a director in the private clients department at ENS Africa. We specialize in onshore and offshore estate planning. We establish and administer trusts. We create wills for various jurisdictions. We administer estates and basically provide services in relation to private clients. I'd like to jump in at this point just to do a quick poll, if I may. And the first question is, do you welcome these new measures to the Trust Property Control Act, or do you believe they are unreasonably onerous and excessive? I just want to give a few moments for people to answer that question. And Cindy, okay, excellent, thank you. So most people said yes. I agree. Remember, the primary purpose of the amendments are aimed at making it more difficult for criminals to launder money through trusts. Overall, I think it will certainly drive the correct behavior expected of trustees, and the amendments will bring greater legal certainty and protection to beneficiaries, and of course, facilitate the work of law enforcement agencies. Cindy, can we launch the second poll? Do these amendments create additional risk for trustees, sufficiently material to justify reconsidering trusteeship appointments? Okay, as soon as you have those answers, can you just let us know, Cindy? Okay, this is virtually a resounding yes. 83% of participants say that it's sufficiently material to justify reconsidering trusteeship appointments. So the way forward, which is becoming clearer, is that it's necessary for trustees to seek legal advice to assess the impact of the amendments on their responsibilities and to ensure legal compliance. The amendments include stricter requirements on trust administration and disclosure, which could increase the trustees' liability and expose them to litigation. For me, it is an opportune time for trustees to review their duties and evaluate whether they have the necessary expertise to discharge them adequately. The ultimate decision, however, to accept or decline an appointment should be based on an individual's assessment of the risk and responsibilities. One thing we can be certain of is that there's no place in our law for a sleeping or puppet trustee, and these new regulations reinforce that. Thank you very much. That's all from my side.
Thanks, Dion and Annika. Really interesting and thought-provoking, not necessarily in a really good way. There's been a certain amount of confusion, I think, in the marketplace about whether these new rules and compliance obligations have also been introduced from a tax perspective. And my reading of the situation is that the only tax amendment that we actually have in play at the moment has to do with the, so to speak, conduit principle as it applies to non-resident beneficiaries of trust. So there are no tax changes per se that have come in parallel with the changes to the Trust Property Control Act. However, I think practitioners may be feeling quite chilled by the inclusion of these questions related to beneficial ownership and effective control, because it appears, and maybe we can talk about this at the end if we have time, it appears that those words have been used in a different kind of defined sense in the legislation to the way in which they're understood and employed for tax purposes. So to give an example, in a discretionary trust, we may find a situation where A has given money to B and B has then settled the trust, how would one answer the question about who's actually the founder of the trust? Is it A or is it B? In discretionary trusts, we often find that we have the named trustees who in law exercise discretion as to the administration of the trust, but in reality, there is a particular person who's giving the instructions and really making the decisions. It's a very, very common practice, certainly in the way in which South African discretionary trusts are run. I think this is going to put quite a serious obligation on trustees to think carefully about how they disclose the effective control of the trust. Are they, in good conscience, able to say that they are, as a body, making all the relevant decisions in the exercise of the discretion that they have? Or are they, Dion, to use the term that you used earlier, are they mere puppets or dummies who are following the instructions of somebody who's sitting outside? And that person may not have a legal right to give instructions, but in practice, de facto, that person might well be pulling the strings. How does one answer these questions when it comes to populating the drop-down boxes on the master's Excel spreadsheet? There's no room for nuance or qualifications or subtlety or saying, yes, the legislation says this, but the legal position is actually different to this. However, I need to tick a box. So I can see quite considerable practical challenges arising for trustees in the way in which this plays out in future. I think there's plenty to talk about there. It's almost a topic in its own right. And I will rather hand over at this point to Eero, who's going to talk about FICA obligations. Thanks.
Robert, Era's just reconnecting. If we can just give her a second.
While Era is reconnecting, maybe we can ask Zane to jump in. So while there's been all of these changes which affect trustees, there's actually been some similar changes to the Companies Act. And it would be interesting for Zane, although not necessarily relevant to trustees, just to quickly run through those.
Sure. Hi, everyone. Thanks, Megan. As Megan indicated, my name is Zane. I'm a partner in the corporate commercial department. And excuse me, as Era will speak to in just a second, the Companies Act has also been amended to align with the Financial Action Task Force grey listing activities. And specifically, the Companies Act has inserted a definition of what beneficial ownership is. It's not a new sort of amendment to the Companies Act. The prior version of a Companies Act amendment in 2021 sought to incorporate a provision regarding true ownership, trying to understand and clarify what or who the actual individuals are that control a particular corporate vehicle, in line again with previous discussions and findings from an anti-money laundering, anti-terrorism, finance sort of perspective. But the point now is, in 2002, the law actually changed with effect from 1 April of this year, where certain additional definitions were inserted in the Companies Act in order to try explain what a beneficial ownership is, or what a beneficial owner is, and what it actually means. And it does so by creating additional definitions in the Companies Act, defining what an affected company is, which is a particular beast of a company, where you've got the historic concept of a regulated company, which is effectively public companies or special companies that are regulated by the Takeover Regulation Panel. That's the one sort of class of companies, and then everyone else. And the obligation to have a beneficial ownership register applies both to everyone else and to the specific types of companies. But there are some nuances and differences as to where they disclose that sort of information and what the authorities do with that sort of information. But as a general construct, the legislation is trying to understand and clarify who ultimately owns a particular organization and who exercises effective control of an organization. Now, both those terms, ultimately owns and exercises effective control, are used, but we don't know what it means. There's no specific definition of that. There is, however, a definition of control, and the legislature does speak in very broad strokes as to what that could mean. And it's defined very broadly to include exercising of control, exercising of the ability to vote. And the idea is akin to what we find in BEE sort of legislation on the see-through principle, i.e. the ability to look through a chain of ownership to actually understand where the buck stops. There's also a new concept about materially influencing management. And again, it's a very interesting concept, but what it actually means, we don't know yet. And the idea is for anyone who owns or satisfies those definitional requirements of a beneficial owner, and for each 5% or portions of 5% or multiples of 5% that one owns, those particular entities need to disclose that to the company, and the company in turn needs to disclose that to the CIPC. There's prescribed manners in which you ought to report that information, and it's going to be interesting as to what the CIPC does with that data. So at the moment, there's draft regulations which were still out for comment, which was published in late March, early April of this year, where the CIPC is empowered to retain the information and to disclose that information on to whoever seeks it effectively. And what that means is could be quite scary for some, particularly in a South African context where we know we've got a history of kidnapping of wealthy individuals, and that could mean your personal data, i.e. your personal identity number, your residential address, etc., is disclosed. But there are indications that the CIPC is looking to limit that disclosure to only certain categories of persons. But again, there's no definitive clarity yet. One last point, Megan, before I let go, is that the CIPC has also indicated that they're going to be looking to apply for more punitive sanctions for people who don't comply with the obligations. So part of the obligations with the beneficial register, apart from recording the details, is to submit data on an annualized basis to the CIPC as part of your annual return. And if you don't comply with that or the other obligations, the idea is that the CIPC would look to impose administrative sanctions. There is already provisions in the Companies Act for that, but they may well be looking to enhance that. And it can be quite excessive. What I mean by that, you could face a penalty of up to 10% of your turnover, which depending on what your turnover is, could be quite significant. There are also other sanctions in the Companies Act which already embed sort of a criminal flavor, but what that actually means in practice remains to be seen. I'll stop there and hand over to Ira, and we can speak longer, but we'll leave it there. Thank you.
Thank you very much. I had some laptop issues. My machine froze, and that's why I left and came back. Hopefully, those are sorted out now. My name is Ira Gunning. Thank you so much for everybody for joining us for our session today. I am in our banking and finance department. I'm a director, and I specialize in consumer protection, data protection, and anti-money laundering. So, of course, these amendments to FEEC have been very, very interesting from my perspective. Just to go back to what Annika spoke about the Financial Action Task Force. And I think we've heard about the FATF so much this year, but I think a lot of people don't know what the FATF is. What the FATF is it's an intergovernmental body, and it is a money laundering watchdog. And it makes recommendations in respect of anti-money laundering. And then it goes and assesses its members against its recommendations to see if we have actually applied its recommendations. We failed the test, and that is why we were grey-listed. And we are a founding member of the FATF. So when you grey-listed, what does this mean? It means other countries see us as a jurisdiction where crooks like to live because it's easy to get away with money laundering. We don't have strong enough money laundering laws, and even if we do, we don't enforce them. So the practical application of this, or implication of this, is that our Financial Intelligence Center and our other regulators are going to try very hard to show the FATF that we've been good to try and get us off the grey listing. And Mauritius was taken off after 2 years, Iceland was taken off after 1 year. So it certainly is possible, but you need to have good laws and you need to implement those laws. So the crooks need to go to jail for us to show FATF that we are applying these laws. Now, today we're focusing on the changes that were brought along in respect of trustees. Now, what happened is in December last year, in an attempt to avoid grey listing, we made a lot of changes to our laws. And like my colleagues have already mentioned, some of these changes were not very, very well drafted because it was past a bit of a rush. One of the changes is a change to the schedules to FICA. Now, the schedules to FICA set out who are accountable institutions. And I know we had a question about this in the Q&A as well. So traditionally, it was our lawyers, it was our banks, it was financial services providers. Now we also have a new category called a person who carries on the business of preparing for or carrying out transactions, including trustees, related to basically any verb: investment, safekeeping, control, or administering of trust property within the meaning of the Trust Property Control Act. So our starting point is to check, what does the Trust Property Control Act say? What is trust property? And there it simply says any movable or immovable property, including contingent interests in property. So not only would it be physical property, buildings, houses, assets, it would also be things like shares, which are basically administered in terms of a trust instrument. So if you've got a written trust instrument and there's some sort of property, then you are doing something with property within the meaning of the Trust Property Control Act. The next thing that we try and play with is what is meant by in the business of doing the following transactions. Can we say some trustees are not in the business of doing administration, safekeeping, control, and so on? Unfortunately, the only thing that we have to work with is a draft PCC Public Compliance Communication 6A released by the FICA, by FIC. And we are often asked, are these PCCs law? They are not. They are just the views of the regulator. But if you don't stick to their views, they ask you for reasons for why you didn't comply with their views or implement their views. And this draft PCC says business is not defined in the amendments to the Act or in the Act itself. So we must give it its ordinary meaning. And it says to us, it's some sort of commercial activity. It's not a charitable undertaking. It's not a government institution. It's not if you do something on an occasional basis. It is not when you do something on a personal basis. So that is all we can work with as far as what is a business. The commentary on the draft PCCs closed already in January this year, but the FIC has got a dedicated compliance core contact center that you can contact. But quite honestly, I don't think you get very useful answers. One of my clients said, we do the following, are we a credit provider? And they said, you are a credit provider if you meet the definition in the schedule to FICA. I also want to warn you that Christopher Vermeulen, the Executive Manager for Compliance and Prevention at the FIC, released a statement in March 2023. And he said the 90-day period that you had to register as an accountable institution has run out. It's on our radar that some of your new accountable institutions have not yet registered. And basically, we are coming for you. You are non-compliant. Non-compliance in the case of a human being can lead to a penalty of 10 million rand. So very important, it's these individual trustees who must go and register with the FIC. So it is not the trust itself, it's the individual trustees that would have to register with FIC as an accountable institution. When you're an accountable institution, you need to do training, you have to have a risk management and compliance program, you need to roll out customer due diligence, record keeping, and you have to report certain transactions to the Financial Intelligence Center. Just want to mention to you that ENS Africa, we have compiled what we call a FICA toolkit. It's got a template for an RMCP. It includes some training. It includes a board circular if you need that to set out the liability of boards and the like. So if anybody is interested in this method to fast track compliance, please feel free to contact me. And that's it from me. I think I hand back to you, Megan.
Thank you so much, Ira. And thank you to our other speakers as well. It's been very interesting to get the context of these amendments. And just by way of introduction quickly, my name is Megan and I'm a practitioner in our tax department. Rather than giving some additional content, I'll be asking our panelists some of the burning questions we have about all of these amendments. So to start off with, Ira, just to be very clear, is this then an obligation on all trustees to register as accountable institutions, or is it more fact specific than that?
It's very fact specific, Megan. So it is only those who are in the business of providing these trustee services in respect of trust property. So again, we only have that PCC to turn to see what is in the business. But for example, one of my clients runs a charitable trust. They registered as a PBO, and there we said you don't have to register as a trustee. But where you act as a trustee for BE Trust, Employee Share Scheme Trust, there we feel that it is some commercial activity. It is not personal, it's not private. Absolutely, you have to register. So I think almost the majority of trustees would have to register, but if it's, for example, a straightforward family trust, and I know we had a question like that in the chat, straightforward family trust, then we can argue it's in your personal capacity and you don't have to register.
Thank you so much, Ira. That's very helpful clarification. Going back to Diana and Annika, we act for a lot of clients who have quite broad classes of beneficiaries in their trust instrument. How should trustees of those types of trusts approach their obligations under these amendments? Is it sufficient for them to have that description of the class on file and submit to the master? Or is there an obligation to go further and to get details of the individual members of the class? And adding on from that, what and when needs to be submitted to the master?
Megan, that's a very good question. It's quite topical. In many instances, trustees are not in possession or have access to the information of the individual class members. Take a large community trust, for example, where there are thousands of beneficiaries. In our opinion, where the beneficiary is a community of persons, we believe that it would be sufficient to take a pragmatic approach and list the community as a beneficiary. The individuals constituting the community are not individually named. If there is one natural person who effectively controls the community and its property, for example, the chief, the trustee ought to disclose his prescribed details.
Thank you so much, Dion. And would that apply to every trust who has a class of beneficiaries?
It certainly isn't a one-size-fits-all type of situation, and specific legal advice would need to be taken in relation to each trust. The circumstances in relation to a community trust might be very different to a more specific, smaller scale employee share incentive trust or a BBEE trust, for example, where the prescribed information might be more accessible or reasonably attainable. Megan, what's important to note is that if the trustee knows or have reasonable grounds for believing that the named beneficiary is just a front, and that hiding behind that front is a natural person who indirectly ultimately owns the trust property, then that natural person would fall under paragraph A of the definition of beneficial owner, and his or her details would have to be disclosed. There's no way around that.
Thank you so much. Sorry, Annika, I was going to hand over to you to answer the question about what and when needs to be submitted to the master.
Thank you, Megan. So just to note there that the regulations do provide for the prescribed information to be submitted on the master's electronic register. However, when the electronic register is not available, so for instance, if the master's portal is down, the regulations then provide that you have to approach the master's office. So what we see here, and just to remember, trustees have the obligation to keep the information up to date. So our advice would probably be that the trustees must, as soon as practically possible, update that information and submit the information either manually or through the register on the electronic platform.
Thank you, Annika. And in relation to these trusts which have classes of beneficiaries, in certain cases, there are requirements for the class of beneficiaries to have representation on the board of trustees. Would the amendments we've discussed today apply to those representative trustees as well? For example, in the case of BBBE trusts, or is there some way to indemnify those specific trustees or exclude them from these obligations?
Megan, the duty applies equally to representative trustees. Remember, one of the main features of SA trust law is the joint action rule of trusteeship. What this means is that the duty falls upon the trustees as a body acting jointly in the performance of their duties. They may, of course, delegate the function to any one of them or even to an outside third-party agent, but the ultimate responsibility lies with the trustees. So if there's negligence, mistake, or an omission, they could all be held responsible. Regarding indemnification, the old common law position was changed, whereby trustees could validly be indemnified for breaches out of the trust fund. Section 9 of the Trust Property Control Act altered the position, which states that a trustee cannot contractually be indemnified in the trust instrument where he fails to show the required care, diligence, and skill expected of him. Thus, any provision in the trust instrument limiting liability or indemnifying the trustee would be invalidated by this provision.
Thanks, Dion. So is there anything practically that trustees could be doing to limit their exposure under these amendments?
Yes, certainly. There's nothing prohibiting a trustee from seeking financial protection outside the provisions of the trust instrument. It is recommended that trustees take out adequate professional indemnity insurance from an insurance company and take expert legal advice on their responsibilities.
Thanks, Jan. And I think a final question that we're wondering about is whether these amendments also apply to foreign trustees administering property in South Africa.
Again, that's a good question, because this situation is certainly caught under the Trust Property Control Act. In fact, one of the amendments introduced, as Annika explained during her presentation, deals directly with this question. Section 8 now makes it mandatory for a foreign trustee to obtain authorization in the form of letters of authority from the master. In terms of the amendment, the word may in the old provision has been deleted and substituted to say that the foreign trustee shall act in that capacity only if authorized thereto in writing by the master.
Thank you very much, Dion. So that's the main list of the big questions we had. I think there are definitely some that have come through on the Q&A, which we'll need to reach out to individually on. As we've spoken about, there's quite a lot of fact-specific thinking that needs to go into these amendments and how they apply in various different scenarios. But to close off, Robert, would you like to say a few final words?
After I can encapsulate everything that's been shared with us in a few words, I just want to thank the panelists for their incisive and compact presentations. I think they've told us a lot in a very short time. So thanks very much for that, and well done. To our clients, thank you very much for attending. We look forward to your questions, because the practical questions help us interpret what the legislation actually means in practice. So please feel free to send those through to us and we'll communicate. You'll find our contact details will be sent through to everybody who's attended today. So if you don't have it, don't worry, we'll send it through to you. And we will also send through a link to the recording for anybody who's missed it or wants to perhaps share it with other colleagues. I have no doubt we'll be saying a lot more about the implications of this legislation, either in future webinars or in our various newsletters. So watch the space. Thank you very much. Have a good day.
Thank you. Bye.